welcome to Ipsy Dixit, a podcast on legal scholarship. I'm Mabel Romero, assistant professor at the Northern Illinois University College of Law. My guest today is Michael Mannheimer, professor at Northern Kentucky University Chase College of Law. We'll be talking about his paper today, Vagueness as Impossibility, which is forthcoming in the Texas Law Review. So I'm really excited to talk with you today about this paper, and it seems that the void for vagueness doctrine is kind of having this moment right now in scholarship. I just talked with Cynthia Godso from Brooklyn Law about her paper with regard to the void for vagueness doctrine as well.
Yeah, I heard that one. That was, thanks for having me, by the way. It is really having kind of, as you said, a resurgence in the scholarship, I think partly driven by some of the recent Supreme Court cases.
Yeah, and I want to talk with you about those in a little bit too, because it seems like, it's been kind of just ignored for a while, and suddenly there's this questioning as to whether it's even a valid doctrine or not, and how to go about applying it. But I just wanted to, orient a lot of our listeners who aren't necessarily legally trained on what the two big rationales for the void for vagueness doctrine really are, what they're supposed to be, I guess.
Yeah, so the Supreme Court has justified the void for vagueness doctrine, so let's back up a little bit from there. The Supreme Court says that statutes that are unduly vague or indefinite are totally void. And the two rationales the Supreme Court has given are one, that it is too indefinite. It doesn't give potential actors sufficient notice of what's illegal or what might subject them to civil liability. I focus on criminal, but it's been applied to non-penal statutes as well. And then the second rationale is that unduly vague statutes delegate too much lawmaking power to non-legislators, to judges, to juries, to police, to prosecutors, concomitant with that. And some people posit this as sort of a third rationale, but I kind of think of them as going together. There's sort of a rule of law rationale that, if too much legislative power is delegated to these executive and judicial actors, we really have the rule of law. We just have the rule of, it's law by cop or law by judge. Law by prosecutor, yeah.
Law by prosecutor, something like that. Okay. So this sounds sort of like, kind of, for those who are listening, who might be a bit more familiar with this concept, sort of a non-delegation, but also separation of powers sort of issue. So has the Supreme Court really focused on one of these two a bit more than the other, or have they really determined that one's more important than the other at all?
Yeah, well, they say that the second non-delegation constraint is sort of the more important aspect of the doctrine. And you're right, it does have a lot to do with separation of powers, which makes sense when we're talking about federal statutes, because we have separation of powers constraints in the Constitution that are fairly obvious at the federal level, not quite as obvious at the state level, but there's a great piece by Chapman and McConnell in the Yale Law Journal from a few years ago, talking about due process as separation of powers. So you can read a sort of separation of powers / non-delegation constraint into the due process clauses of the Constitution as well. But the Supreme Court has sort of emphasized that for about the last 35 years or so. They've said that non-delegation aspect is the more important of the two rationales.
Okay. So the doctrine has been under some attack of late, right? Could you explain that for us?
Yeah, and that's part of the reason that I got interested in this topic, is that there's been sort of some daylight between Justice Thomas and Justice Gorsuch on a number of issues. A lot of people thought that they would, vote in lockstep when Justice Gorsuch was appointed to the court. But it's fun to see the differences between the two. And one of the differences between the two is on this issue. Justice Thomas, in a couple of cases in the last 4 or 5 years, has taken the position that the void for vagueness doctrine really is not a constitutional doctrine, that the court really has no place in striking down vague laws as a violation of due process, that it really comes from what's called the rule of lenity, which deals which applies when a statute is ambiguous rather than vague. The main difference being, we can think of an ambiguous statute as having a set number of possible meanings, usually 2, sometimes 3, sometimes more, but it's got a finite number, a small number of possible meanings, whereas a vague statute has sort of an infinite number of meanings. And Justice Thomas says it's really about the rule of lenity. It's really about interpreting unclear statutes narrowly to favor the defendant in a criminal case, which is not a constitutional doctrine. It's just a rule of statutory construction. Legislatures can get rid of it if they wanted to. And Justice Gorsuch has come back in the latest case, Sessions versus DiMaia, which was an immigration case. And he wrote a separate opinion concurring in the judgment. This opinion attracted some attention in the popular media because it was Justice Gorsuch joining the so-called four liberals. And he wrote a concurring opinion, or an opinion concurring in the judgment, sort of defending the void for vagueness doctrine on constitutional grounds, going back to Blackstone and some of the cases from the 18th century. And I talk a little bit about that the 19th century. I talk a little bit about that in the article.
And it's really interesting reading the article and going through some of the history that you lay out, and even some of the more recent sort of opinions that you see dealing with the void for vagueness doctrine, because as you kind of hinted at, we have this at least I think popularly, a lot of Americans have this idea of, okay, there's this liberal side of the court, there's this conservative side of the court, and they're going to always decide on issues, including dealing with the void for vagueness doctrine, in exactly the same way with each other, and never the twain shall meet. And it's interesting to see that sort of interplay that you were talking about, between Gorsuch and Thomas, and kind of the differences that they have here. I think it's really fascinating.
Yeah, and even before Justice Gorsuch joined the court, Justice Scalia, whose seat Justice Gorsuch took, Justice Scalia and Justice Thomas really had sort of the same split. Justice Scalia wrote the opinion in United States versus Johnson, which was a 2015 case, I think, and Justice Thomas wrote a separate opinion, agreeing with the result, but disagreeing very much with the whole void for vagueness doctrine that the court has set up.
So I want to talk about the difference a bit more about the difference between ambiguity and vagueness. And you were talking about how, okay, if you've got an ambiguous statute, you might be able to, perform in accordance with that statute, even though, or one of the interpretations of that statute could have 2 interpretations, 3 interpretations, or something along those lines, versus a vague statute, which there's no way to perform with it. Could you give us some examples maybe as to an ambiguous statute versus a vague statute maybe?
Sure. For the way I explain it to my students is, if you think about ambiguity, it's sort of if you think about the optical illusion of the rabbit or duck, right? It's either a rabbit or a duck, depending on how you look at it, but it's one or the other. A vague statute is more like an ink blot. You get 100 people in, and they'll give you 100 different answers as to what the ink blot means. But in actual statutory terms, an ambiguous statute. Good example, the one that I used in the article is from the Muscarello case, where the statute forbids, carrying a firearm in relation to a drug offense, and Muscarello had a firearm, I believe it was in his truck while he was dealing drugs, wasn't on his person. So the question was, does carrying a firearm mean having it on your person, or does it mean just having it with you when you're traveling somewhere? And it had to mean one or the other. Whereas a vague statute, trying to think of a good example, Colander versus Lawson was considered vague. The statute there was considered vague, where it required someone to provide a police officer with credible and reliable identification, where reliable was really, up to the individual police officer. So, what that could mean, it could mean any number of possible things depending on what police officer you got.
Exactly. So you have a police officer essentially legislating and imposing
Right.
their belief and their interpretation as to what reliable means or reasonable means. Or there's an interesting case that you talked about, or at least gave an example of, when it came to a vague statute where people couldn't congregate on a sidewalk and engage in annoying behavior or something like that. And to me, annoying behavior from the public could be something, I'll be honest, pretty wide ranging, but it might not be to other people. So I thought that was a really good example of what exactly vague looks like.
Yeah, that's another good example. That's from Coates versus City of Cincinnati, my adopted hometown, where an ordinance, forbade two or more people from, or I guess it was three or more people from standing on the sidewalk and engage in behavior that's annoying to passersby, which, as I say in the article, could be something as trivial as wearing Argyle socks with sandals, something that I've been known to do. Yeah,
That is pretty annoying, I've got to tell you. Got to stop that.
yeah.
Um, but when you have these, well, let me backtrack a bit. Don't ambiguous statutes and vague statutes present relatively similar problems? I mean, you've got the same notice problems, I would think, the same sort of, potentially, legislating by the executive sort of problems with cops determining what, statute means, or a prosecutor really, shaping what that means, or perhaps even, the court coming and shaping it however they wish. Um, what practical cures have been used to fix these issues in the past?
Yeah, so exactly, and that's when I said that the difference between Justice Gorsuch and Justice Thomas was one of the things that prompted me to write this. Really, the big thing that prompted me was this sort of riddle in criminal law. Um, in my criminal law course at the beginning of the semester, we look at vagueness, we look at ambiguity, and you're right. The void for vagueness doctrine and the rule of lenity, which says that ambiguous statutes should be interpreted narrowly when possible, they're both justified by the same rationales. The rule of lenity is also justified by these sort of notice and non-delegation / separation of powers / rule of law rationale. The one being an individual rights rationale, one being more of a structural rationale. That ambiguous statutes, again, they don't give notice to the average person, what is criminal and what is not. So Mascarello, in deciding, can I, assuming that he did this, which is sort of counterfactual probably, but assuming he thought about it, can I keep this gun in my truck while I do this drug transaction? Well, the statute says I can't carry it. What does that mean, right? So he wouldn't know from the outset what he was forbidden from doing. And there's a certain non-delegation problem there too, because especially with regard to prosecutors, because prosecutors will have a tendency to read statutes as broadly as they can. And so in writing ambiguous statutes, what legislatures are doing is sort of leaving it up to prosecutors as to how broadly or narrowly to interpret the statute. They'll interpret it broadly, which will cover more people, which gives them a lot more discretion as to whom to prosecute. Whereas if it were a narrower statute, there'd be a much smaller pool of people for the prosecutors to prosecute. They could still exercise some prosecutorial discretion, but it's to a lesser extent. And the prosecutors will have that discretion unless and until some court of last resort interprets the statute in a definitive manner. So the rule of lenity says, courts should interpret statutes narrowly to try to head off. So maybe a prosecutor at the outset will sort of realize this statute will ultimately be interpreted fairly narrowly. So maybe I shouldn't interpret it broadly and prosecute all these people. So that kind of culminates for me in sort of a riddle, which is, why is the void for vagueness doctrine a constitutional doctrine? And the rule of lenity is not. The rule of lenity is not constitutionally required. In fact, many states have passed statutes saying courts don't apply the rule of lenity anymore. The rule of lenity is this common law rule dating from, back to the 1700s perhaps. But it is just a rule of statutory construction, and legislatures can abrogate it. So perhaps this led me to think, well, perhaps Justice Thomas is right, that neither one is constitutionally required. Actually, when I started writing this article, I was sort of thinking exactly the other way. I was thinking, well, maybe the rule of lenity is constitutionally required. Maybe there's something, some form of the rule of lenity that's constitutionally required. But I quickly disabused myself of that notion when I realized that states had started abrogating the rule of lenity, even before the 14th Amendment was ratified. So it'd be difficult to argue that the framers and the ratifiers of the 14th Amendment understood it as incorporating some form of the rule of lenity. But to my mind, either they're both constitutionally required or neither one is constitutionally required. It's odd that they're both justified on the same two rationales, but one is a constitutional doctrine and one is not.
Yeah, that is really odd, actually. And what I really want to discuss now, after looking at this sort of conundrum, and it does feel kind of like this really confusing riddle. Why is one seen as constitutional and why is the other not? And your solution here is, I think, really fascinating. Your solution is to prescribe against requiring the impossible. Can you explain to us what that means?
Yeah, so, dating back over 400 years, in Dr. Bonham's case, Lord Coke tells us Parliament cannot compel the impossible. And it's such an obvious proposition that people don't really talk about it that much. The legislature can't compel us to go 6 months without drinking water, or to fly around the house once a day. And this I think this idea that the legislature can't require us to do the impossible it provides a better way of thinking about vagueness and ambiguity than simply thinking about it in terms of how difficult it is to understand the statute. Because how difficult it is to understand, how indefinite a statute is always going to be a matter of degree. Which I think is part of the reason why the void for vagueness doctrine is so muddled. The court has to draw lines, and where they draw lines, it seems to many people, I'm not the first one to make this observation, certainly, seems fairly arbitrary. But if we think about it in terms of legislatures not being permitted to require that we do the impossible, I think it makes it easier in some cases to figure out what statutes violate due process and which ones do not. It explains. Let me start by saying it explains why ambiguous statutes don't violate due process. Because if a statute is ambiguous, if there is a narrower reading or a broader reading, you can always comply simply by giving it the broader reading. You can always assume the broader reading holds, and I'll just give the statute a wide berth and comply with the broader reading. Now, that might not be the best reading. The rule of lenity tells us that's not the best reading. If legislatures draft ambiguous statutes, they might be deterring non-harmful behavior if it's worded too broadly. They might be deterring socially beneficial behavior if it's worded too broadly. But as I say in the article, that's not really a constitutional concern. It's a policy concern, but it's not really of constitutional magnitude. But with a truly vague statute, like the ones that we talked about, the ones in Coates and in Collender, where it's an offense to gather with two or more people and not be annoying to passersby, well, there's really no way to comply with that other than by not showing up in public, which I suppose is technically possible, but I think we would say, well, that's practically impossible to not show up in public with two other people, because anything you do while you're in public with two other people could be deemed annoying to someone with very delicate sensibility. So it's truly impossible to comply with a statute like that.
Or really curmudgeonly sensibilities, maybe like mine. So I want to talk about how your solution really addresses some of the problems that you highlight with the sort of traditional, well, is there a traditional understanding, I guess an older understanding of the void for vagueness doctrine? So you talk about the void for vagueness doctrine as being rather under-inclusive in application. So how exactly would this fix that concern of under-inclusivity then?
Well, it doesn't seek to fix it. It simply points out that the void for vagueness doctrine is under-inclusive. And again, I'm not the first person to make this observation. Carissa Hessek has a great article where she talks about how um, uh, there are statutes other than vague statutes that involve the same kinds of improper delegations or excessive delegations. If we think of, any statute that's clear but broad, traffic offenses are probably the best example, where people they're clear. Don't go over 35 miles an hour is pretty clear, but people are constantly violating it. Police can't stop everybody, and so it gives police excessive discretion, on who to stop. Or, for more serious types of statutes, we can think about a statute like was involved in United States versus Yates, which again was clear, as Justice Kagan said in her dissent in that case. It's clear but broad, where the statute said prohibited destroying, in relation to any official proceeding, any tangible object. That was the operative language. And the court interpreted that very narrowly to exclude a lot of things, but tangible object really isn't ambiguous. A tangible object is a tangible object. It's something you can hold and feel and see and touch. But it's incredibly broad. And so there are excessive delegation / rule of law problems with lots of statutes that are not vague. There are problems with statutes that are clear. There are problems with statutes that are ambiguous but not vague, as we said before. And so that observation leads me to the conclusion that this non-delegation aspect or excessive delegation aspect or rationale for the void for vagueness doctrine is really not what's driving the doctrine, or really not what should be driving the doctrine, because that problem is not peculiar to vague statutes. That problem is much more widespread. And my suggestion, it's a little cut out, but at 88 pages, I didn't want to add more articles. This is sort of a separate article, but what I say is, we should come up with a separate doctrine that forbids excessive delegation in all of these contexts, whether we're talking about vague statutes, ambiguous statutes, statutes that are broad but clear. They all exhibit the same problems of allowing excessive allowing for excessive delegation. And if there's and perhaps there is a due process prescription against legislatures excessively delegating, but it's not peculiar to vague statutes by any means. And I think, by focusing on vague statutes, it's almost counterproductive, because there are so few statutes that are so indefinite that they're going to be declared vague. And what we're doing is pot shots at random statutes that are vague, and we say, well, they implicate excessive delegation, and we're ignoring a whole mass of other statutes that do the same thing, but they're not vague. And so we should do something about the disease rather than just one symptom of it, which is vague statutes.
Great. Yeah, and that makes a lot of sense. Where it's like, why are we just focusing on just the vague statute versus, making this a bit more inclusive? But what I found really interesting too is that, um, some people might feel like, okay, this is such a crazy new way of looking at, the void for vagueness doctrine, but it isn't necessarily. I thought that it was interesting going back to, some of the older cases from the United Kingdom and everything, and taking a look at some of those cases where it's like, okay, this concept of focusing on impossibility isn't necessarily new, I guess, right?
Yeah. If you look back at the very beginning of the the Supreme Court's sort of foray into the void for vagueness doctrine, what you'll find is cases that really are about statutes that just made it impossible for people to act. So, for example, the very first case, and I think it was 1914, the International Harvester case, sort of hinged criminal liability on growers of a commodity not charging more than the value of the commodity, under perfect market conditions. And there was just no way for anyone to figure out what the value of a commodity would be under perfect market conditions. Now, I mean, we can figure out the value of a commodity. It's what people are willing to pay for it. But the way the statute was drafted, the growers had to figure out, well, what would the value be? What would people be willing to pay for it if the market didn't have these imperfections in it? So it wasn't so much that it was hard to understand. I mean, it's that you can sort of explain that. You can explain the concept. It's just impossible to comply with. The problem is, soon after that, the court, I think, took some wrong turns, as I say in the paper, and started applying this doctrine with a vengeance to statutes that really were difficult to understand, maybe, or were, they had some indefinite language, but they weren't impossible to comply with. So charging unreasonable rates for necessities, for example. Well, again, you can figure out what a reasonable rate is by looking at the market, and you can give the statute a wide berth by, making sure you don't charge, a whole lot, or maybe charge, just to be safe, charge less than what you think you should be charging, in order to make it absolutely positive, absolutely sure that you're not violating the law. And I think those cases have sort of been almost disavowed by the courts. But if you look back, like I said, to International Harvester, the very first case, it really is, if you look at that statute, it really was impossible to comply with it.
So it seems like they've taken this sort of, this track that you were looking at in this paper, and looking at impossibility, but then just sort of applying it like gangbusters. Like, okay, let's just throw it around willy-nilly and use it here and here and here, when it wasn't really all that appropriate. And you have this really interesting section in your paper, like you were talking about, where, these are the instances where the court kind of takes some wrong turns. But what I found really interesting is that when we look at your sort of idea of using this impossibility standard instead, it helps to make a bit more sense of some other cases that might not necessarily make sense, like when you take them as a whole. So maybe could you explain some of those for us by any chance?
Well, I'm not sure which ones you're referring to.
Yeah, like you have a section in your paper where you talk about how, look, some of these court cases, they try to apply these weird scienter requirements, they try to do this weird stuff, and it doesn't necessarily make sense until maybe you start, understanding, okay, maybe there's this influence of this impossibility concept.
Oh, yeah, okay, yeah. The scienter, the scienter fix,
Yeah.
which the court started using in around the 1950s, I think, where they said, well, if there's a scienter requirement, if the person has to have some kind of criminal intent to be guilty, then it's not vague. And that's really been attacked by a lot of people who there are two sides to that argument, and I try not to take sides in the article because I don't really have to. Um, but there's a good argument on the one side to say, well, just because a statute requires that someone intend to um, commit or commit some conduct, that doesn't make the statute less vague because they still don't know that their conduct violates the law. Scienter only refers to the mental state that attaches to the performing of the conduct. And then there are other people on the other side who say, well, that makes too much of a distinction between fact and law. And I don't, like I say, I don't take sides on that issue, but what I do say about that is it makes sense if you think that the Scienter thing makes sense if you think about it in terms of impossibility, because once you intend to do something, then you can no longer claim that it was impossible for you to refrain from doing it, right? If I wear argyle socks with sandals with the intent to annoy someone, well, I could have refrained from doing that if it was my intent all along, not just to look fashionable in the way that I think is fashionable, but to actually annoy people by doing it. Well, I could have refrained from doing that. Now, that would be a really stupid statute. And it might have other constitutional problems if there's a First Amendment right to dress as I please. That would certainly run aground on the shoals of the First Amendment. But it's not a vagueness problem. If I and it also explains. And I forget who is the again, this is not my own, but I cite the article in my piece. Not the first person to make this observation, but it also explains why attempt liability is not irretrievably vague. Anyone who teaches criminal law, I think, encounters the frustration of students and my own frustration when we go over attempt doctrine and the courts say, well, mere preparation is not enough, but perpetration is attempt. And there's some line between preparation and perpetration that courts have been very unwilling or maybe incapable of supplying to us. And we have a really wide range of doctrines on where that line is, on where someone commits an attempt. And that would be, if you think about vague statutes, attempting to do X would always be considered vague, but for the fact that it also requires the specific intent to do X. And so you can always absolve yourself of criminal liability by simply not intending to do X, which is always under your control. So it's always possible to comply with an attempt statute.
Well, I think that we pretty well covered everything that I was hoping to cover. Is there anything else that you just kind of wanted to leave us with regard to this paper that really sticks out that you want to impress upon all of us?
Well, I think it's interesting that in the 18th and early 19th centuries, courts were actually talking about vagueness and impossibility, sometimes together in the same case. And I think I think courts have always sort of confused the two. I think they've talked about them sort of at the same time as if they're the same thing. And I guess what I'm trying to do is to untangle those strands. Because a vague what we might think of as an indefinite statute will often be impossible to comply with, or will sometimes be impossible to comply with, but not always. So I think it's sort of a subtle distinction. It's not like I'm saying the void for vagueness doctrine is just 100% wrong. It's that we're really focusing on the wrong aspect of what is problematic about these statutes. And what's problematic about these statutes when there is a problem, it's that they're impossible to comply with, not that they're difficult to understand.
So it's more of a reframing of the concept then.
Yeah, it's a reframing. I think it's a subtle shift, but I think it would be an important shift if courts were to sort of recognize that.
Awesome. Well, thank you so much for joining me today. And this was a really fun piece. And I do hope that you follow up on it soon. It sounded like you've got more projects related coming down the chute.
Yeah, I'm thinking about it. I've got a bunch of things I'd like to do, but yeah, I think I will.
Okay, fantastic. And yeah, you got to stop wearing those socks with sandals, man. That's just not
never.
Okay, no, that is annoying. But thank you for joining me. And yeah, I'm looking forward to seeing the final product.
Thanks.
This is Les Paul
and Mary Ford. School bells ring and children sing. It's back to Robert Hall again. Mother knows for better clothes. It's back to Robert Hall again. You'll save more on clothes for school. Shop at Robert.